and you please mute your mics. Okay, today is Tuesday, February 2nd, 2 o'clock. We're in conference room 325, and everybody else is on video conferencing. Our first bill today is House Bill 184, tax appeals. And first up is Isaac Choi.
Good afternoon, Chair and members. Josh Michaels, Department of Tax, on behalf of the Director. We stand on our testimony offering.
Jessica Orr, Judiciary.
Hello, good afternoon. Jessica Orr for the Judiciary with Beth Palma from the Tax Appeal Court. We'll stand on our written testimony and are here for any questions.
Okay, thank you very much. And Tom Yamachika, Tax Foundation of Hawaii.
Our concern was basically that the bill, as it's described in the secondary sources, seemed to be a clarification bill, but it's really not. The effect of the bill is to basically say, you know, you pay $100 or whatever it is for a tax appeal, you're not getting it back under any circumstances. That presently conflicts with the tax appeal court rules, as well as you know, the present language of the statute. So just wanted to make sure that everybody knew that. I'd be happy to answer any questions.
Okay, thank you very much. That's all the testifiers we have. Members, are there any questions for any of the testifiers? Okay, seeing none, we will move on. House Bill 186, related to the Uniform Trust Code. First, we have Eric Young, Judiciary.
Good afternoon. My name is Eric Young. I'm a member of the Probate Committee and appearing on behalf of its Chair, Chief Judge R. Mark Browning, and other members of the committee. We stand in support of House Bill 186 relating to the Uniform Trust Code. I stand available for questions.
Thank you very much. Next, Blake Oshiro, Hawaii Commission to Promote Uniform Laws.
Good afternoon, chairs, members of the committee. Blake Oshiro here on behalf of the commission. I'll stand on my written testimony in support, and I'm available if there are any questions. Thank you.
Okay, thank you very much. Okay, members, that's all the testimony we have on House Bill 186. Any questions? Okay, sensing none, we move on to 189, relating to designating substitute judges on the Intermediate Court of Appeals. First, we have Randy Pinal, Judiciary.
Good afternoon, Chair, Vice Chair, and committee members. My name is Randy Pinal. I'm the supervising staff attorney at the Intermediate Court of Appeals, and thank you for allowing me to testify today. Because this is a judiciary package bill, I wanted to offer just a few brief comments to support my written testimony and to underscore the importance of this bill to the ICA. The ICA is comprised of 6 judges and it functions in panels of 3. If a judge retires, then we go down to 2 judges on the panels to which the retired judge was assigned, and 5 judges on the court overall. Then we have to replace the retired judge in all of their cases to get a 3-judge panel. The way the statute is currently written, and mind you, it was written long ago when the ICA had only 3 judges on the court, but now that we have 6 judges, we first have to look to the 3 other judges on the court before the Chief Justice can appoint someone from outside to fill a vacancy, which basically means if the remaining judges do not have a conflict, then every time there's a vacancy on the court, every time a judge retires, then 5 or possibly fewer judges would be doing the work of 6 judges for however long it takes to fill that vacancy. This bill would essentially normalize the judge's workload by allowing the Chief Justice to appoint a substitute judge as soon as there's a vacancy. So we would always have our full complement of 6 judges, even if one is sitting only in a temporary capacity. And the impact is felt not only in the decisions on the merits, but the court also handles 2,000 to 3,000 motions every year. So it makes a big difference to each judge's workload when 6 judges are working on the cases and the motions rather than 5 or fewer judges. Those are all the comments I have, and I'm available for questions.
Okay, thank you very much. Next, DJ Marie Iha, ballot section. She's not here?
Sorry, what's
DJ Marie Iha.
No.
Okay, okay. Thank you. Madison Hines.
There is no, not
Okay. And then Lance D. Collins. The support. Okay. Then that's all the testifiers we have on House Bill 189. Members, any questions? Seeing none, we go on to House Bill 563. Relating to sex offenders. Michelle Fu, Deputy Attorney General. Okay, AG has filed in opposition. Darcia Forrester, Office of the Public Defender.
Aloha, Chair Nakashima and members of the committee. The Office of the Public Defender believes this measure fails to include provisions for victims who want their family members to return home. We completely understand that many victims will want residential restrictions imposed, but many families seek reunification and want their family member to return. We are concerned with the all or nothing approach in this current version of the bill. The bill does not mandate communication with the victim to determine if that individual actually wants a housing restriction or opposes a housing restriction and wants reunification. We are concerned that this approach would be detrimental to restorative justice. Some victims may have changing opinions over time, especially 5, 10, 20, or even 30 years after an offense and after counseling, therapy, and the completion of offender-focused treatment. In essence, victims seeking residential restrictions do not and cannot speak for every victim in every circumstance, and the bill does not take that into account. So those are our concerns, and I'm available for questions. Thank you so much.
Thank you very much. Next, Randall Platt, Honolulu Police Department.
Good afternoon, Chair and committee members. Randall Platt for the Honolulu Police Department. We stand on our written testimony in support of the bill. I'll be available for questions.
Thank you very much. Next, Stephanie Sakamoto, Sex Abuse Treatment Center.
She's not on the call.
Okay, in support, Kathy Lee, individual.
She's not on the call.
In support, and Glenn Nagao, individual.
Is it Scott Nagao? Is that not?
Glenn Nagao.
I'm not going.
She's not on, they're not on the call.
They're not on the call. Okay, thank you. Okay, that's all the testimony we have on House Bill 563. Any questions, members? Representative Matayoshi.
This didn't work. Can I talk to the AG, Deputy AG? Oh, I'm sorry. Pooh is not here yet.
Yeah, the public defender is here.
Actually, no.
Yes,
Oh, okay. No question. Members, any other questions?
I have a question. Chair,
Yes, Representative Nakamura.
Thank you. Yeah, I also had a question for the Attorney General's office, but maybe the public defender might be able to answer my question about how many sex offenders are we talking about that would be impacted by this bill? Do you have any?
I am so sorry. I don't have raw numbers. I think we'd have to get that information directly from the Attorney General's office.
That's what I thought. Thank you.
Apologies.
Any other questions, members? Okay, seeing none, we will move on. House Bill 356. Related to the Judicial Council. E. Campbell, Hawaii Ethics Commission.
Good afternoon, Chair, Vice Chair, and committee members. The State Ethics Commission stands on its written testimony with comments. Thank you.
Thank you very much. Ron Miley, Judiciary.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, members of the committee. We'll stand on our testimony with comments, and I'm available to answer any questions, and thank you.
Okay, thank you very much, Mr. Miley. Sandy Ma, Common Cause.
Good afternoon, Chair, Vice Chair, members of the committee. We stand in our written comments. Thank you.
Okay, thank you very much. And Kathy Lee, individual. No Kathy here? Okay. Okay, that's all the testifiers we have on that bill. Members, any questions? Seeing none, we'll go on to the next bill, House Bill 481. Relating to informal meetings. Cheryl Kakazu Park, Office of Information Practices.
Good afternoon, Chair, members of the committee. I'm Cheryl Kakazu Park, Director of the State Office of Information Practices, testifying in opposition to House Bill 481. This bill proposes to amend one of the Sunshine Law's permitted interactions to allow all members of a county council to jointly attend informational meetings that are open to the public. Ironically, it would limit other boards' ability to use this permitted interaction to attend professional conferences and seminars that are not open to the public because they have a registration fee. The amendment is also unnecessary because all members of a county council are already able to attend community meetings under the existing guest meeting provisions found at HRS section 92-3.1B. This provision was added in 2014 primarily in response to Maui Council members' desire to allow all of its members to attend a meeting open to the public as guests of a community group or another board. Specific safeguards were included in the guest meeting provision at the behest of OIP and good government groups. Council members can already do what they want to do under the existing guest meeting provisions without having to amend the permitted interaction provision as proposed in this bill and messing up other boards' use of the permitted interaction to attend informational meetings and conferences. I'll be happy to answer any questions that you have. Thank you.
Thank you. Chair Alice Lee, County Council. Okay. All right, next, Douglas Miller, League of Women Voters in opposition. Sandy Ma, Common Cause Hawaii.
Good afternoon again, Chair, Vice Chair, members of the committee. We stand on our written comments. Thank you.
And thank you very much. R. Brian Black, Civil Beat Law Center in opposition. Sterling Morita, Hawaii Chapter Society of Professional Journalists in opposition. And then Kathy Lee, an individual, in support. Remember, Bill, any questions? Sensing none, we'll move on to the next bill. House Bill 529. Oh, I'm sorry, Representative Matayoshi.
Sorry, for OIP, for 481, you said that it's already covered under 92-3.1B. I'm wondering, I'm looking at the statute right now. I agree with you that it does seem to cover largely the same subject matter, but with a whole bunch of extra requirements. Which one of these require? I guess I'm wondering how impactful you feel these requirements are, because it requires videotaping, notice beforehand. Have you heard any complaints about these requirements, and maybe that's why this statute is coming up, or this bill is coming up for hearing? Oh, you're muted.
One of the requirements is that the county councils are supposed to submit an annual report to the legislature each year on the effectiveness and application of these provisions. To my knowledge, they haven't. So I don't know what it is that they're complaining about, because in the past, when they've wanted to go to a community meeting, I've readily agreed. We haven't stopped them from doing so. Now, these specific safeguards in here were put in 2014 at the behest of League of Women Voters. I'm not sure if Common Cause was involved, but I know League was, we were. So these are just to ensure that they don't run amok with this provision that allows all of them to attend, you know, a meeting of another board or a community group. So we don't see the problem here, because they can do what they want to do under this provision.
Is there anyone?
They haven't complained to us about it. Huh? Sorry.
I'm wondering, is there anyone from the county, any county council here that might be able to opine on whether they feel the restrictions in HRS 92-3.1B are overly, you feel they're overly restrictive, and that's why you need further latitude?
I don't think anybody else there from the county council is
Okay,
there.
but thank you for clarifying that.
Any members, any other questions? 481. We're seeing none. We move on to House Bill 529 related to residential real property. Susan Alden, individual, in support. Dawn Burgess, individual, in support. Kalani Burgess, an individual, in support. Chad Taniguchi, in support. Heidi Belinsky, in support. Ron Ogomori, in support. Joseph Bruson, individual, in support. Lawrence Lau, individual, in support. Nancy Rowe, individual, in support. Eric Ching, individual, in support. Bill Hicks, individual, in support. I believe Bill is here.
I am, Chair.
Please proceed.
Mahalo, Chair. My name is Bill Hicks. I live in Kailua. I believe this bill would effectively remedy the problem we had in Olamana last year, where a drug house was allowed to fester in the neighborhood for many months, and the property owner was uncooperative. I appreciate Representative Matayoshi's efforts and support that aspect of this bill. Unfortunately, as written, I think an unintended consequence could be property foreclosure or heavy fines against an innocent property owner who tries but is unable to prevent or remedy harmful actions by a tenant. So in my written testimony, I suggested that the bill be modified to add a provision which essentially is that if the property owner, who is limited in what they can do when they have tenants, if the property owner in good faith tries to remediate the situation with the tenants but is unable to, and then starts the long process of eviction, that if the property owner seeks the eviction of the tenants or occupants who are responsible for the violations, then fines or foreclosure action against the property owner because of tenant or occupant caused violations shall be held in abeyance. And I believe this is a fair and necessary addition to this bill because it puts property owners at risk of $150,000 in fines in a month and ultimately foreclosure of their property if they try but are unable to get their tenants to remediate the problem. So I think that adding that provision to protect innocent and conscientious property holders while putting at risk uncooperative ones would better balance the bill. Mahalo.
Thank you very much. And last we have Geraldine Bess, an individual in support. The members, any questions?
Chair.
Representative Ward.
Thank you, Chair. Because this involves HPD or the police department for the enforcement, I regret that I'm not able to ask them a question. I'd like to see what they think of it. But if there's anybody who has testified who knows what other fines are $5,000 per day when there's such a per day fine as high as this, I'd like to know. It seems a little bit exorbitant for something that, as the gentleman just explained, sometimes the landlord not able to handle a tenant gets away with this, and then it ends up to be $150,000 per month. That is very, very, very steep. Does anyone know, Mr. Hicks, do you have a comparable figure for $5,000 per day fine?
Representative Ward, no, I'm not aware. Sorry.
Is anyone else aware of that? If not, my colleague knows it from Hawai'i.
For illegal transient vacation rentals that receive a notice of violation, the fines can go up to $10,000 a day.
But it starts out at 1 or 500 and it goes up. This is like 5,000 a day right at the get-go. That's where I'm thinking, particularly as Mr. Hicks said, you know, sometimes there's circumstances where the landlord, because of an intransient tenant who can't be evicted, et cetera, is going to get stuck with an arm and leg. Anyways, Representative Matayoshi may have something.
Chair, I just want to point out that they do have a 90-day notice of violation period to remedy this. So it's not like the fine gets immediately imposed. There is a period of time where they can remediate it. And if they choose to remediate it and are showing that they are trying to in good faith with the Department of Planning and Permitting or otherwise, it's very likely that this fine will be continued on. But it's only if that the landowner is really not making any effort to either communicate or remedy the situation that this fine would likely be imposed with a notice of an NOO, a notice of order, and then the fines would start to accumulate. So there is quite a bit of leeway already built into the system. When you're talking about a landowner that's basically flaunting the law and endangering the neighborhood, I feel like a $5,000 fine is justified in this case, and it needs to be sufficient or a fine that will escalate quickly enough to justify a judgment lien, a lien being foreclosed upon on the property.
as well.
Thank you for that. That's very helpful. It, however, raises the question, what is the experience rating on who actually creates this problem or has created? Is it homelessness people occupying, as some of the tenants or some of the testifiers have said? Or is it people who are just having bad tenants? What's the experience rating on this? In other words, what's the problem we're trying to solve for who?
Yeah, you can answer the question.
Yeah, in this particular case, what we had was a case in Olomana, or the Olomana subdivision, which is a pretty quiet subdivision typically. And the owner of the home refused to allow the police in, was no longer at the property, and just a host of homeless drug addicts were coming to the property. Got to be a very dangerous situation for the community. People didn't feel safe leaving their house. There was a gun involved. There were some, without going into the details too much, there were some very terrible illegal things happening in that house. And the HPD's hands were tied. They couldn't go in because the owner was specifically telling them, I am not allowing you to go into this home. So the police could respond to noise complaints and such, but this situation dragged on for well over a year. And I was involved for quite a good chunk of it. And we managed to get the situation resolved, but it was through a lot of effort behind the scenes, which shouldn't have been the case. If the situation, the point of this bill is to remedy this situation if it happens again. And I know from just talking to other people in the neighborhood and in all of our neighborhoods, there's always that one problem house that the police, and you guys all know which ones in your neighborhoods I'm talking about. You know, there's those problem houses that the police really, their hands are tied. This is trying to give some kind of enforcement action because DPP, they've told me they will not foreclose on a property, no matter how high the fines are. So a big part of this bill is giving residents a light at the end of the tunnel. It's saying that if they keep on going after 90 days, it's forcing DPP to start the foreclosure process, which is not immediate. It's a long process, but at least there's some relief for the community that can be offered by the government instead of just hoping the problem goes away. So it's really giving people some kind of solution at the end of the day that they know if this is not going to go on forever, the government is going to do something if it continues to go on and they continue to flaunt the law.
Thank you.
Okay, thank you very much. All right. With that, we're on to House Bill 72 related to electric scooters. First, we have Insurance Division, State of Hawaii. Okay, with comments. Next, Ed Sniffen, Director of Transportation, Department of Transportation, Highways Division, in support.
Hi, this is Christy from DOT. Good afternoon, Chairman Nakashima, representatives and committee members. For Ed, I'm Christy Kauser. We do stand on our written testimony in support of House Bill 72. Thank you.
Thank you very much. East Emmons, County of Kauai, in support. From Department of Transportation Services, the County of Honolulu, testimony in support. Walter Ozeki, Honolulu Police Department, in support.
Good afternoon, Chair, committee members. I'm Major Ozeki from the Honolulu Police Department. We'll stand on our written testimony in support of this bill, and we're available for any questions.
Thank you very much. Jonathan Hopkins, Lime, in support.
Good afternoon, Chair, Vice Chair, and members of the committee. We'll stand on our written testimony in support of this bill and stand available for any questions.
Thank you very much. Brianna Bledsoe, Spin, in support.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members of the House Judiciary and Hawaiian Affairs Committee and staff. My name is Brianna Bledsoe, Senior Public Policy Manager for SPIN. We are excited to support HB 72 relating to electric scooters, and we stand on our written testimony. Thank you for the opportunity to testify, and I am happy to answer any questions that you may have.
Thank you very much. Yeah, that's all the testimony that we have on House Bill 72. Members, any questions? Representative Ward.
Thank you, Chair. This is to the DOT or HPD. How does this bill read comparable to other states? Hawaii was a bit of a latecomer, late bloomer for these electric scooters. Do other states have comparable 75 pounds and particular age descriptions, et cetera? Do any of you know that? If so, it would be helpful to know.
Hi, this is Christy Kauser from DOT. Yes, they do range from about 15 years old to 17 years old, depending on what their laws are. And the weight of the vehicle can be about 50 to 75, depending on what the county or state had limited it.
Okay, so we're right in the mainstream, if you will, in terms of this bill.
Yes, sir.
Right? How many states have it already? You know?
I would have to double check that because I know that a lot of them were on hold as we had been because of COVID.
Okay, thank you. Thank you, Chair.
Thank you.
You members, any other questions? Seeing none, we'll move on to House Bill 350 related to attachment of real property. Stephanie Sakamoto in opposition. We have Marvin Dang in opposition and Neil Okabayashi in opposition. So the testimony we have on this matter, seeing that there are no testifiers to ask questions to, we will move on to House Bill 201 relating to elections. First, we have Scott Nagao, Office of Elections.
The office will stand on its written testimony in support and be happy to answer any questions. Thank you.
Okay, thank you. Jade Fountain Tanigawa in support. Kathy Kaohu, County of Maui, Office of the County Clerk in support. Rex Kidilla, City County of Honolulu, Office of Elections in support. Tom Hendricks, County of Hawaii, comments. Greg Kubis, Hawaii County Republican Party in opposition. He's not on the call. Okay, Sandy Ma, Common Cause in support.
Thank you, Chair, Vice Chair, and members of the committee. We do support HB 201, but with some amendments and some clarifications. We support HB 201, Section 1, having ballots mailed from at least 18 days before the election day until 7 days before election day. We also support HB 201, Section 2, starting ballot tabulation 18 days before the election day. We do have some concerns about Section 3 of HB 201, especially giving the clerks unilateral decision to open voter service centers at any day and for any time. We think that's too much latitude for the clerks. The clerks should not have the unilateral ability to decide this without any guidance. We're concerned that this could result in just having one voter service center open for one day for half a day. So that's a real concern. There should be some guidelines established and given to the clerks. And we provided these guidelines in our written testimony, and I will not repeat it here. We also think that guidelines should be given to the clerks for establishing places of deposit or drop boxes. We also are seeking a clarification within Section 3 as to when ballots are to be, when drop boxes are to be opened, when ballots are mailed. It wasn't exactly clear from the language in the bill that drop boxes can be open at different times in the counties when ballots are mailed, because ballots are mailed on different days throughout the counties, so as not to overwhelm the Postal Service. Thank you for the opportunity to testify in support of HB 201 with some amendments and some clarifications. If you have any questions for me, I'm happy to answer them. Thank you.
Thank you very much. Dave Anderson, Common Cause Hawaii in support. Robert Shimea, Indivisible Hawaii in support. And then we have Kelly Lopez, AARP in support. And then we have about a dozen individuals also providing testimony in support. However, no one indicated that they would be here today. Members, are there any questions to the testifiers? Representative Ward.
Mr. Nago, is this bill representative of the lessons learned from the long lines in Kapolei and Honolulu Hale? If so, how so?
Yes, so the long lines that were experienced on general election day were isolated to the election day itself. If you went the day before, if you went on Monday before the election, there was relatively little lines or no lines or very little wait, I was informed. So this bill would allow the flexibility to open up additional voter service centers on election day rather than having it to be open the entire 10-day period, which the law now requires.
What is your estimation, given the amount of time and the number of people in the lines? How many would have worked better had we known how many people would have shown up? In other words, how many on election day would you suggest in 2022 if this bill passes?
It's really up to, if this bill were to pass, it would really be up to the county clerks to establish additional voter service centers in addition to the ones that they already have. And it would also allow them to have the flexibility of having it on not all 10 days, but certain days. So they could have it for a week, they could have it for 3 days, they could have it on election day.
Let me rephrase the question. How many people actually, after the polls closed, still, how many people voted after 7 o'clock on November 3rd?
How many people? That would have to be a question addressed to the county clerks because that's something that they would have kept track of.
Because I would think there would be an empirical basis on which you could say, look, there were 5,000 people and we need so many to make sure that they vote within a certain amount of time. This seems a little bit loosey-goosey is the point that I'm making here. It seems like it should be tighter given that we've done something, and if we've learned anything, we should know exactly what should be done. The other question I have, Chair, is about the at least 18 days before the election. Does that mesh with, again, the experience of yours? It should be at least 18 days rather than before it said approximately in the original bill?
Are you referring to allowing us to, are you referring to the place of deposit? Or are you referring to the processing of ballots?
It's the each registered voter in the counties is to be enabled for voters to receive their ballot. This is for voters to receive their ballot at least 18 days before the election.
Yeah, so currently it says, the law says about 18 days. So we're saying at least 18 days. So you would have at least 18 days to have your ballot voted and return it by election day. So it could be 18 days, it could be 19 days, 18 days, or it could be more.
And that would indicate then, you know, how many people were late getting their ballot? How many people got their ballots in because it wasn't on time, 18 days? Or is 18 days everybody had the chance and you only had how many that came in after that and you didn't count them?
That would be,
you don't know.
I would have to defer to the county clerks on that question, but my understanding was there were not that many ballots that were received after the deadline.
So why don't we say 15 days instead of 18 or 12?
Because we want to give voters the most time to receive their ballot, vote their ballot, and send it back in the mail if they choose. Given, if you recall, in the general election, there was an issue with the post office shutting down services. So they were recommending that your ballot transit time would be longer. This would address that.
But the percentage who mailed in versus walked in on these service centers, do you have any numbers? Or again, that goes back to the county clerks. You wouldn't know that.
It's like 96% of the voters in the general election actually voted through either a drop box or through the mail, and it was about 4% that actually voted in person.
4%. Okay. Thank you very much. Thank you, Chair.
Okay, thank you, members. Any other questions? Representative Nakamura.
I have a question for Mr. Nago. I wanted to find out, it seems like this bill still allows the same day registration on the day of election, the night of election, up until the closing of the closing time. So I was just wondering, a lot of us went to bed that night not knowing the results. And it said, it was because people were registering on that evening, right before, the deadline, but they were in line. So that's what I understood, stood up the sort of delayed the vote count. So I was just wondering what would be done, what does this bill do differently that would prevent that in future elections?
So this bill does two things to address that. People having to go to a voter service center. One is if you're not registered to vote by the deadline, you can register to vote at a voter service center. The other is it allows ballot mailing to continue up until 7 days prior to the election. So currently the law says you have 10 days or 14 days to mail for the clerks to mail out ballots. If you update your address, update your registration or your address after that, you would have to go to a voter service center to correct that. By allowing clerks to mail ballots up until 7 days prior to the election, a lot of those voters wouldn't have to go vote in person to make that change. They could still update it either online or filling out an application and still get their ballot mailed to them. The other thing is by allowing flexibility of having additional voter service centers on different days or election day, for example, they could open up an additional voter service center on another part of the island just for election day.
Okay, so these provisions then would allow you to get results by the 10 o'clock news.
As long as somebody doesn't, as long as voting has finished at the voter service center. So if there's one person in line who can't make up their mind, are still voting, we cannot release results.
Thank you, Chair. Thank you, Scott.
Okay, thank you. Members, any other questions? Okay, seeing none, we will recess for decision making. Recess. Okay, members, reconvening the 2 o'clock hearing of the Judiciary and Hawaiian Affairs Committee. First is House Bill 184 related to tax appeals. Chair's recommendation is to pass this forward as is. Members, any questions or concerns? Sensing none, Vice Chair.
All right, now voting on HB 184. Chair's recommendation is to pass as is. Chair and Vice Chair vote aye. Representative Ichiyama? Aye. Representative Kobayashi?
Aye.
Representative Lopresti?
Aye.
Representative Lowen?
Aye.
Representative McKelvey?
Aye.
Representative Nakamura?
Aye.
Representative Takumi? Representative Todd? Representative Tokioka? Excused. Representative Ward?
Aye.
Chair, your recommendation is adopted.
Okay, thank you very much, members. Next, House Bill 186, relating to the Uniform Trust Code. Chair's recommendation is to send the bill out in an amended form. Throughout the bill, the bill creates 11 new articles, and Chair's recommendation is that we replace article with section, with part, and indicate the parts by Roman numeral 1 through 11. That on page 25, line 13, we insert a comma after ascertainable, and other technical amendments needed for clarity, consistency, and style. Members, any questions? Comments? If not, Vice Chair, House Draft 1.
Our Chair's recommendation is to pass HB 186 with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? All right, Chair, your recommendation is adopted.
Thank you very much. House Bill 189, relating to designate substitute judges on the Intermediate Court of Appeals. Chair's recommendation is to pass this as is. Members, any questions or concerns? Seeing none, Vice Chair.
Voting on HB 189, Chair's recommendation is to pass as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you. Next, members, House Bill 563, relating to sex offenders. Members, on this, the chair is concerned about the objections raised by the Attorney General's office, and will recommend that we defer this at this time. Next, House Bill 356, relating to Judicial Council. Members, on this, the Chair's recommendation is that in light of the concerns raised by several on the deliberations on the selection of the Ethics Commission and the Campaign Spending Commission, that those deliberations continue to be closed. However, other proceedings of the Judicial Council be open. Members, any questions or comments? Seeing none, Vice Chair, House Draft 1.
Now voting on HB 356, Chair's recommendation is to pass with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? Okay, Chair, your recommendation is adopted.
Okay. Thank you very much. Members, House Bill 481 relating to informal meetings. The chair's recommendation is that we continue to move the bill on, and hopefully we'll get more insurance testimony by the council people that are pushing this. And so I recommend that we move this forward with technical amendments, and it will go on to finance. Members, any questions or comments? Seeing none, Vice Chair, House Draft 1.
Chair's recommendation is to pass HB 481 with amendments, noting the previously excused member. Any members voting with reservations? Any members voting no? Sorry, Rep. Takumi, was that with reservations or no? Okay. No from Rep. Takumi. Any other members voting no? With all other members voting aye, Chair, your recommendation is adopted.
Thank you very much. House Bill 529 related to residential real property. Chair's recommendations that we pass this as is. Members, any questions or comments? Representative Ward.
Sure, I have some reservations, and I forgot to ask the question, why couldn't they get a warrant rather than have to do all of this $5,000 a day? So I want to still elaborate on how the fine is being done and why particular warrants couldn't be to get into the property rather than this. So reservation.
Reservations?
Exactly.
Okay. Members, any other
comment?
Representative Kobayashi?
Thank you, Chair. So my concern on this is similar to what Representative Ward brought up, that really you can just issue a warrant on this, but I think when I look at the wording on this with regards to imminent threat of illness, disease, or injury, or imminent threat to health or safety, generally that's consistent with what I've seen as laws that are really designed to increase the penalties for disobedience with our health mandates currently. So that, which we already have penalties established for that. So, and if we are going to do that, it should be an honest discussion on any disobedience penalties as opposed to leaving it in general terms like this. But as well as that, I'm a no vote on this.
Okay, thank you. Members, any other questions or comments?
I don't know if he's raising his hand or not.
Rep. Takumi, are you seeking a? Okay. If not, Vice Chair.
Okay, Chair's recommendation is to pass HB 529 as is, noting the reservations of Representative Ward and the no vote of Representative Kobayashi. Any other members voting with reservations? Any members voting no? Okay, Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 72 related to electric foot scooters. Okay. On this one, the chair notes the concern noted by the insurance commissioner, and will recommend that we amend the bill Thank you. Chair will recommend that we amend the bill by adding to section 431 10C 304, a new item D, any user of electric scooters. And that will add to that add to a law that for purposes of this section, the term personal injury protection insurer include personal injury protection self-insurers. Every personal injury protection insurer shall promote personal injury protection benefits from accidental harm as follows. And by adding electric scooters, it adds it to the items that are exempt from this provision. Members, any questions or comments?
Chair,
Yes.
thank you for that amendment. I think it strengthens the bill. Thank you.
Okay, thank you. Members, any other questions or concerns? Okay, seeing none, Vice Chair, House Draft 1.
Chair's recommendation is to pass HB 72 with amendments, noting the previously excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 350, related to attachment of real property. Members, we'll defer this matter. And last, House Bill 201, relate to elections. At this point, I will recommend that we move this on as is. It will go to finance where further discussion can be held. Members, any questions or concerns? Representative Ward?
Sure, my concern is there was clearly a difficulty with the lines in Kapolei and Honolulu Hawai'i. This bill says that the clerks now may add additional voting places. I think my constituents and others would say, why does it not say shall? It's too loosey-goosey to say, hey, look, we had a problem, we're gonna learn from it, but we'll let these guys decide. No, it should be where this legislative body would specify that they will meet the demands on election day because of what basically postponed election for 3, 4, 5 hours. So if we learned anything, I think we should get a bit more specific rather than say, may do this, that we shall have enough places open that the people can vote. With that, I have serious reservations.
Okay, thank you very much. Members, any other questions or comments? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass HB 201 as is, noting the previously excused member. I'm sorry, Representative Ward, were you voting with reservations or voting no?
Serious reservation.
Okay, I'll put you down for serious reservations. Any other members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay. Members, thank you very much. We are adjourned.